pleased to debate the honourable member for Spadina, Harbourfront.
Good morning, Mr. Speaker. I rise today to speak on Bill C-225, the private member's bill sponsored by the member for Kamloops Thompson Nicola. This bill aims to confront one of the most heartbreaking and pervasive crises facing families and women across this country: intimate partner violence. Addressing intimate partner violence is a shared responsibility, and today we have an opportunity to demonstrate that when lives are on the line, collaboration must prevail over division. Gender-based violence must end, and we must ensure that survivors receive the protection and justice they deserve. I want to thank the member opposite for bringing this bill forward. His efforts reflect a genuine commitment to ensuring that our justice system responds effectively when individuals, often women, face threats to their safety. I also commend the Minister of Justice for engaging closely with the sponsoring member, the provinces, territories, survivors, and experts on this issue. This is exactly what Canadians expect of us: to work together, to problem solve, and to put people before politics. When Parliament addresses issues with focus, urgency, and compassion, it offers not only policy solutions, but hope, not just to survivors, but to all Canadians who believe in the power and potential of this House. Today, our task is both clear and urgent. We must strengthen protections for those at risk, close the gaps in our justice system, and ensure that violence is met with action and not silence. Mr. Speaker, while Bill C-225 may appear tough, strength on paper does not always translate into protection in practice. As drafted, this bill risks punishing the very individuals it seeks to protect. Rather than restoring trust in the justice system, there is a real danger that survivors, especially women, could lose even more confidence in our legal institutions. Any legislative response must be thoughtful, rooted in evidence, and grounded in the lived experience of survivors. This means listening to experts in gender-based and intimate partner violence, working in lockstep with the provinces and territories who administer the justice system, and most importantly, centering the lived experience of survivors. Their voices must ground our approach. As drafted, Bill C-225 duplicates existing offences, automatically imposes automatic first-degree murder charges, and significantly restricts police release discretion without regard to context, coercive control, or self-defence. It may make for compelling headlines, but it does not make for sound evidence-based policy. In fact, Bill C-225 could create harmful unintended consequences, both legal and human. It would place additional burdens on an already strained provincial justice system, potentially causing delays, barriers to prosecution, and the inconsistent application of justice. This strain could further erode confidence for survivors already facing fear, trauma, and risk. Mr. Speaker, intimate partner violence demands careful and thoughtful treatment under the Criminal Code. Blanket measures that lack flexibility fail to recognize the realities of coercive control, the cycles of abuse, and the life-threatening circumstances faced by many victims. Most concerning is the real possibility that victims, particularly women defending themselves against violence and life-threatening abuse, could be penalized rather than protected. Under this bill, a victim who kills their abuser in a desperate act of self-defense could face an automatic first-degree murder charge. That is not justice, it is traumatization. It is not protection, it is punishment. And it is not what survivors deserve. We need legislation that protects survivors, holds perpetrators accountable, and supports the justice system in delivering better outcomes. This is how we build trust, not erode it. Mr. Speaker, our approach is different. Criminal law must reflect the full spectrum of intimate partner violence, including coercive control, psychological manipulation, economic abuse, and the pervasive cycles of fear and entrapment that survivors experience. That is why our upcoming intimate partner violence reforms will be targeted, trauma-informed, and grounded in the voices of those who experience abuse firsthand and those who work directly on the front lines. IPV is complex. It cannot be adequately addressed through isolated or symbolic amendments, but through meaningful and modernized legal reforms that truly protect survivors and hold abusers accountable. A survivor-led approach is essential. Survivors had told us that punitive measures alone do not necessarily create safety, and in some cases they can create risk. Real reform must reflect lived realities and address the root causes of violence and not just its outcomes. It means building on the excellent work of organizations like Next Gen Men, who promote emotionally supportive and positive masculinity, challenging the harmful gender norms that often drive violence. It also means addressing socioeconomic conditions like poverty, financial dependence, and housing insecurity that keep too many victims trapped in cycles of abuse. Experts like Julie Lalonde have told us that intimate partner violence is not limited to physical harm. Her work on coercive control, stalking, and bystander intervention has helped shape national conversations about how violence often begins before it becomes visible. She reminds us that protection is not just about reacting. It's about recognizing early warning signs, intervening sooner, and ensuring survivors know they're not alone. Another survivor, Atiya Khan, has challenged Canada to rethink how we talk about intimate partner violence, centered not only on punishment, but on healing, accountability, prevention, and survivor empowerment. While there are many contributing factors to intimate partner violence, we know this for sure: it must end. Real progress comes through prevention, capacity building, early intervention, and strong supports. Mr. Speaker, there is much work ahead. But this government's commitment is unwavering, and we are doing the work outside of legislative reforms. Through the National Action Plan to End Gender-Based Violence, we have invested more than $500 million, $539 million, flowing directly to provinces and territories. Importantly, at least 25% of that funding is specifically dedicated to education and prevention initiatives, because protecting survivors means not just responding to violence after it happens, but also working to prevent it before it occurs. I recently participated as part of the Standing Committee on the Status of Women in their study of gender-based violence and femicides, as well as on Section 810 of the Criminal Code. Expert witnesses such as Louise Riendeau of Regroupement des Maisons pour Femmes Victimes de Violences Conjugales shared some important concerns regarding Bill C-225 as it is currently written. In her testimony, Madame Riendeau shares that, on the one hand, Bill C-225 simply repeats most offences and places them in the context of intimate partner violence. That maintains the logic of isolated incidents, which wouldn't be the case if there were instead an offensive coercive control. In other words, rather than recognizing ongoing patterns of abuse, this bill maintains a narrow, incident-focused view of violence. That approach fails to capture the lived realities of survivors. She went on to warn of another troubling impact of the bill. Under the proposed framework, she notes, a victim who left marks on their attacker by biting or scratching them while they were being strangled would be charged with a crime against an intimate partner, just like a controlling and violent spouse. Mr. Speaker, this means that a victim acting in self-defense while fighting for her life could be charged in the same way as the perpetrator. These concerns show why simply duplicating offenses or automatically classifying all intimate partner violence as first-degree murder fails to reflect the full spectrum of intimate partner violence, especially those rooted in coercive and controlling behavior. Rather than protecting survivors, it risks criminalizing them. Rather than bringing justice, it risks re-traumatizing them. And rather than enhancing safety, it could silence the very voices we are trying to empower. Mr. Speaker, we must ensure that our reforms protect victims, not punish them. We must build laws that reflect reality and not just react to it. Mr. Speaker, collaboration across party lines on intimate partner violence is not only important, it is critical. If we are serious about reducing the violence that affects women, children, families, and communities, then we must work together with determination. In that spirit, our government intends to put forward amendments that strengthen this bill, not to dismiss its intent, but to ensure that it truly protects survivors and does not unintentionally criminalize them. Criminal law must reflect the full spectrum of intimate partner violence, including coercive control, ongoing patterns of abuse, and physical assault. That is why our government will be proposing targeted amendments to ensure victims are not captured under the first-degree murder clause, to modernize the seized property regime, and avoid unworkable bail measures. The government can support meaningful reforms that actually enhance protection for survivors while maintaining charter-compliant, evidence-based policy. These reforms will be grounded in evidence developed in close consultation with provinces and territories, ensuring that the law is informed by those who administer justice and by those who experience abuse firsthand. Our government, with the largest women's caucus in Canadian history, is committed to making Canada safer and protecting victims of IPV. Protecting women is not a partisan issue, and we will continue to work with survivors, communities, and all levels of governments to ensure targeted, evidence-based reforms. Thank you.